Hi, everyone, and welcome. My name is Catherine Sinelli. I'm a coordinator with the Family Focus Resource Center. We serve families of children with disabilities in North Los Angeles County. And we put on workshops like this. We also offer support groups. We help connect families to services, regional centers, special education services, and community resources as well. I'd like to welcome you all today. This is the fourth and final session of our IHSS workshop series with Disability Rights California. Our presenter today is Maria Iriarte, and she is a senior attorney. So I know we have lots to cover today. So Maria, I'm going to go ahead and turn it over to you.
Thank you. So let's get the show on the road, as they say, right? Good morning, everyone. Thanks for being here. I say this about all the IHSS trainings. This is the most important, but it really is an important topic because a lot of people I've found in more than 20 years of doing this work, most people don't appeal because they don't know what to do. How do you prepare for a hearing? Like, what's the procedure? Because hearings have procedures, have things that you need to do before you get to the hearing, at the hearing. That's one area. The other area is, how do you prepare for what you're going to hearing on, right? Depending on the issue, right? So this is what the training is all about. The first part, we're going to talk about notices of action and appealing. We're going to talk about preparing for a hearing, what happens during the hearing, and things that could happen after the hearing. But we're going to talk throughout the presentation about Emilio and his case. So his mom received a notice of action dated January 5th of this year, indicating that they were going to terminate his protective supervision because of two things. Because they're saying that he's self-directing and that he doesn't need supervision 24 hours a day, 7 days a week. Emilio's a 12-year-old with autism and auditory processing disorder. He's been getting protective supervision for a number of years. And so when mom got this notice of action, she was quite surprised, upset. She doesn't understand reasons for taking away the protective supervision, because in her mind, her child needs to be supervised and needs the protective supervision. So she receives the notice of action, and in the back of the notice of action, there is a section on what to do when you are not happy with the result, and that's appealing, and we're going to talk about that in a moment. But what a notice of action does, and it's required by law that governmental entities who provide public benefits need to provide a written notice of action when an action is taken. So, for example, if you apply for IHSS and they deny you, you have to get a notice of action. If you apply for IHSS and they say yes, you have to get a notice of action. And you'll also get notices of action when they want to take away a service, reduce a service, or deny a service that you're asking for. And so these notices of action are really important because it tells you what is happening, why it's happening, the regulations and the laws that support what they're doing, and also an explanation of your right to request a hearing. Normally, you have 90 days from the date of the notice of action to appeal. But if you've been getting IHSS and they're going to reduce or take away a service, then you need to appeal before the effective date of the notice and ask for aid paid pending, so that whatever it is the county wants to take away won't happen on the effective date of the notice. And you're going to be asking for aid paid pending, so nothing will happen on the effective date of the notice until there's a hearing. And if you win the hearing, then you continue with your service. So I want to explain effective date of the notice. This is a typical notice of action. You've got the date of the notice. Remember, here in Emilio's case, the date is January 5th of 2024. So on the right side, it would be January 5th, 2024, case information, etc. over here. And then it says here, let's say that it says, as of July 5th, 2024, your protective supervision hours are going to be terminated. And so in order for this not to happen, when July 5th comes around, mom needs to appeal before July 5th and ask for aid paid pending. The effective date of the notice is not the date of the notice. It's up here. It's when the thing will happen. And the thing will happen the thing is that the county's going to take away the protective supervision, and that's going to happen on July 5th. But if mom appeals before July 5th and asks for aid paid pending, when July 5th comes around, nothing will happen to Emilio's protective supervision. Mom will go to a hearing and hopefully win the case. So that's what I mean by effective date of the notice, asking for aid paid pending. The notice of action can also instruct you on what information the county needs. And so if you get a notice of action that says that they couldn't approve the application, for example, because the county didn't get, for example, the health certification form, or something, then what you want to do is get a hold of the county worker and provide that information so that they can issue a new notice of action, hopefully with what you want. Language access. So if you've indicated to the county that you want your notices in your primary language, like let's say Spanish, and Spanish is one of those languages that at least 5% of the population in your county speak, then the county is required to provide the notice of action in your primary language. So let's say we're talking about LA County. Definitely more than 5% of the people in LA County speak Spanish. So it's one of those threshold languages that where you can ask for it. So if the county can't provide a notice of action in the primary language, it has to provide interpretive services under these scenarios. If within 90 days of the notice of action, the claimant or the person who received the notice is receiving the benefit, tells the county that she or he needs an interpreter, or if the claimant told the county that they need a notice of action in the primary language and tells the county within 90 days of the date of the notice of action. So if you want interpretive services. If you receive, if you've asked for notices of action in your primary language and you get a notice of action, let's say Spanish, and you get it in English, that could be a ground for allowing you to appeal aid or to request aid paid pending later than usual because you didn't get your notice of action in your primary language. So, but you have to indicate to the county that what it is you want. There's also, when we're talking about notices of action, something called timely notice. So the law says that the written notice has to be mailed to the person who's going to be affected at least 10 days before the effective date of the action. So I've seen these cases where someone receives the notice after the effective date of the notice. That's not timely notice, and that doesn't prevent you from asking for a hearing or asking for aid paid pending, which is called the State Fair Hearings Division. That's the division that hears these types of hearings. I'm sorry, sorry about that. So sometimes when I talk to people and I they've received a notice of action, I've asked them if they've appealed, and they say to me, I don't know how. Then that indicates to me that they didn't read the notice all the way, because the notice has to have the, you know, it talks about your right to appeal, how much time you have to appeal, request any paid pending, how do you know where to send your appeal? You can call in your appeal. There are different ways to appeal. And here is the California Department of Social Services is the entity that administers the IHSS program statewide. So you're going to find a lot of information on IHSS in the CDSS website, and State Hearings Division is within CDSS. So you're going to find information on requesting hearings. But let's go. Actually, I'm going to open this link, and so let's go there. So California Department of Social Services, state hearings request. And it talks to you about if you disagree. So how do you request a hearing? You can do it online. I'm going to talk about expedited hearings in a moment. You can call them and ask for a hearing. You can do it in writing by sending it to this address. I don't trust the mail so much. So if I'm going to ask for a hearing, I've always done it by calling the State Hearings Division. And when you call in for a hearing, 9 times out of 10, you're going to get your case hearing number. And if they don't give it to you there and then when you ask for a hearing, I would say call back in a couple of days to get that, because that's really the confirmation that they've gotten your hearing, they've gotten your appeal. So this is the link on how to do it. And then the State Hearings Office, if we go there, we've got different different offices in Sacramento. Northern Regional Office, Los Angeles Regional Office. So there's a lot of information on the CDSS website. Okay, and that was the link that we went to right there. Okay, hold on a minute. Sometimes people get their notices of action and they've got 90 days to appeal. And they don't know whether they should or they shouldn't. I always say, if you're not quite sure whether you're going to appeal or not, appeal anyway within the time allowed, because you can always withdraw your appeal. It's much harder to appeal late, beyond the time that you have to appeal. You're going to have really good cause for not having appealed within the time that the law allows. And this is an all-county letter that was issued by the California Department of Social Services that talks about, here a minute, hold on a minute. Let me just move this. The process for withdrawing from a hearing and rehearing request. So, if you're interested, you could always get to this link for more information. So Emilio's mom can, sign up for what is called the Appeals Case Management System, and we're going to go to that. So when you file for a fair hearing, you have the option of signing up for, they call it ACMS. And so what that does is that it allows you to do everything electronically. And let me explain what that means. But let me just I'm just opening up that link. So this is the Appeals Case Management System. And Emilio's mom can come here to create an account. And she can, and she's going to, when she creates an account, she's going to set up her username and her password, and she can monitor her case online. She can submit documents online. She can see what the county has submitted online. She can look at the file online at any time. The other way to do it is, if when the county has to give her the position statement and the evidence they're going to use at the hearing, she can say to the county appeals worker, this is the person who's going to represent the county at the hearing. And, I want that. Can I go pick it up, or can you email it to me, or whatever other way to get it? She can do that. But the easiest way to do it is to be able to be on ACMS and handle your case electronically. It's really it's for people who feel comfortable doing that, right? Emilio's mom may or may not feel comfortable doing it. In fact, she thought about it and she decided that she was going to create an account so she can keep up with what's going on in the case by just opening up the account and seeing her son's case file. So that's the ACMS, but you don't have to do it. You can just do it the old-fashioned way. It's perfectly fine to do that. So the link to ACMS is there. You would also find the link on the California Department of Social Services website. So things to consider when you are requesting an appeal. Will you need an interpreter? If you're going to need an interpreter, let them know. If you speak Spanish, but there's a particular dialect, or maybe it's not necessarily Spanish, but whatever it is that you need, you need to let the State Fair Hearings Office know about that you need an interpreter. You can do that at the time of the hearing, anytime before the hearing, during the hearing. So if during the hearing, the mom, let's say Emilio's mom didn't ask for an interpreter, and because she thinks she can, go to the hearing and just without an interpreter. And when she's in the hearing, she realizes that she's not understanding what's going on. So she can stop the hearing and say to the judge, Your Honor, I need an interpreter. I'm not understanding everything that's being said here. And the judge will try to get an interpreter there and then, because they do it on the phone. The interpreter would most likely be on the phone at that point. If not in person, on the phone. And if the judge can't locate an interpreter, then the judge would continue the hearing for another day to be able to get an interpreter for that continued hearing. Let me just tell you, I've had, my experience with interpreters has been that not good quality. I've had to stop hearings because the interpreter was doing such a bad job. The last hearing I did, we had to continue the hearing 3 times before we were able to secure an interpreter that we were all happy with. In one of those 3 times, we didn't even start the hearing. The judge was just giving instructions, and the interpreters were awful. The judge finally said, after the second attempt, on it every day, when I say attempt, it was we had to continue the hearing another day to get an interpreter. After the second attempt, the judge just said, I'm going to have to secure an interpreter through other means, and indicated that they recognize, State Fair Hearings Division recognizes that they're having the quality of interpretation is not that good. That's why if you need an interpreter, you should take someone to the hearing who knows English and your language, so that they can interrupt at any time when they feel that the interpreter is not doing a good job, because every word matters when there's an interpreter. If the client is going to, like, let's say that Emilio is going to be at the hearing and he needs some kind of reasonable accommodation. Let's say that, he can't be sitting down for more than 15 minutes and he needs a break. That may be a reasonable accommodation for his disability. The mom may have her own disability and may ask for a reasonable accommodation. She may ask for, maybe that everyone speaks slower so that because of her disability, she needs that to happen. So if you're asking for, if you're asking for any reasonable accommodations, then this is the time to do that. Of course, you could ask for it at the time of the hearing, but that might postpone the hearing. So you need to be proactive and try to do this before the hearing. Subpoenas. So if there's a document that you want to be presented at the hearing, or a person that you want to be at the hearing, and a subpoena will force the person to be at the hearing, or that the document be presented at the hearing. So if Emilio's mom realizes that the social worker who came to do the reassessment won't be at the hearing, and she thinks it's important that this social worker be there because she wants to question the social worker about the reassessment, she could ask the State Fair Hearings Office to allow her to issue a subpoena to have this social worker present at the hearing. So let's say that Emilio's hearing is next week and mom is not ready for it. She can call the State Fair Hearings Office and ask for a postponement. And the first time they give it to her, they're going to need a reason, but more likely than not, they'll give it to her. But every time after that she wants a postponement, she's going to have a really good reason for that. So by law, you have the right to have an in-person hearing. What the State Fair Hearings Office is doing now is that when they send the notice of the hearing, the date, they're going to say it's by phone. And that's what's going to happen in Emilio's case. But mom wants to be present at the hearing. She wants the judge to see her son. So she could call the State Fair Hearings Office and say, you guys have set the hearing for this day by phone. I don't want it by phone. I want to be in person. And they're going to say to her, well, you know what that means? It means that we're going to have to postpone the one that we've set for hearing by phone. And, it'll just prolong the time that you get to hearing. And she'll say, fine, I want it in person. And she has the right to do that. But she might decide she wants to do the hearing by phone. Sometimes you can ask for video or a home hearing. Let's say that the person whose benefits are being affected wants to be present at the hearing but can't leave the house. Perhaps a home hearing or a video hearing, a Zoom hearing. However, those are things that you need to discuss with the State Fair Hearings Office. Expedited hearings are for situations, there are a lot of people waiting in line for their turn to go to hearing. And so expedited hearing means that you want to cut the line. And so in order to cut in front of the line, you have to have a really good reason for asking for an expedited hearing. I would say a really good reason is the purpose for the IHSS program is to keep people safely at home. And let's say that you're a person who you're at the brink of going into a nursing home because you're not getting the care that you need at home. That, I think, would be a good reason for an expedited hearing. The length of the hearings, typically an hour and a half, 2 hours. If your hearing does not end by that time, it'll be continued to another day. And if on the second day the hearing doesn't end, it'll be continued for a third day. So, I've been at hearings where I've gone 4 times for a case, 4 different dates for a hearing. So mom appealed and asked for 8 paid pending. She's going to get a letter from the State Fair Hearings Office saying, we got your appeal. You're going to hear from the appeal specialist, and this is the person who's going to represent the county at the hearing. And later we're going to tell you when your hearing date is, blah, blah, blah. And then the next thing that mom should receive is that letter from the appeal specialist saying, hi, I'm the one who's going to be representing the county at the hearing. I'd love to hear from you and talk to you about the case. Please call me. And one of their main tasks is to try to settle this case short of going to hearing. Try to resolve the issues before going to hearing if they can. This all-county letter talks about the responsibilities that the appeals specialists have. So if we open it up, here, let me just I'm having a little difficulty here. So let's see. Let's open up this link. So this is the county letter issued in 2017, number 102, issued that year. County hearing representatives' pre-hearing responsibilities, the authority that they have to represent the county and provide aid paid pending, to provide reasonable accommodations, language, communications with claimants requesting language services, identify the issues for the hearing. So part of what the authorized rep wants to do in asking you to talk to them is to clarify what the issues are for the hearing, because they may not be clear from the appeal. Review the county's action. What did the county do here? And there's a lot of information. Perhaps issue a conditional withdrawal, and I'm going to talk more about that. And it talks about access to records. You have access to records to review your records, prior to the hearing. This county representative will issue a position statement. I'll talk about that. And it just goes on. And in here, buried in here somewhere, is that responsibility to try to resolve this case. And people, do resolve the cases from time to time. So, even if you appeal, it's possible that you might not go to hearing because the issues will resolve prior to the hearing. Lastly, usually the last piece of mail that that Emilio's mom will get is the letter with the date, time, and place for the hearing. So there are procedures that need to be followed when you are going to have a fair hearing. The regulations that talk about the procedures are in what is called Manual of Policy and Procedures, MPP, starting at 20-000. There's also something called the Administrative Law Judge Bench Book. This is a manual that judges use to educate themselves on how to handle matters. And we'll go to those. So the procedures on how do you do certain things when you're going to a state fair hearing. We're going to go. So this is Manual of Policy and Procedures, starting at chapter 22.000. Starting with 22-001, there are definitions. Your right to the hearing, requesting a hearing, time limit to request a hearing, acknowledgement of request for a hearing. That's that letter that Emilio's mom got from State Fair Hearings saying we got it. How to set the hearing, group hearings, hearing general rules and procedures for hearings, all about evidence, subpoenas. If you're going to subpoena a witness, there are witness fees and mileage that will be paid to them. And how does that happen? How do you postpone or continue for additional evidence? How do you dismiss? How do you disqualify the administrative law judge? Let's say that you walk into the room and you see that judge and you've had that judge before, and you don't want to have this judge. So what are the reasons that will disqualify a judge? Communications after the hearing with the judge, action by the director. I'm going to talk about that. The notice of decision. You can get during the hearing, they're tape recording everything. And so you could get a recording of the hearing and how to do that. About rehearings, I'm going to talk about that. So there's a lot of good information here. But I want to go to the bench book because that's actually, I find this very helpful too. you look at these things because you want to know, like you have an issue of aid paid pending and the county hasn't given it to you. For example, can I get it from the judge when I go to a hearing, right? So this is the ALJ manual. There's an introduction. Abandonment. What is the judge to do when the hearing starts at 9 o'clock today and the claimant, the person who requested the hearing, doesn't show up? When does the judge consider the case abandoned? And what can the person do to reinstate the hearing, right? So if I didn't get to the hearing because of something, yes, I can call State Fair Hearings and say, hey, I didn't get to the hearing because there was a bad accident. And can I get a new date? But I can also look at abandonment section here of this manual to see how that could be treated and how much time I have to ask for a new hearing. Aid paid pending. Sometimes you can ask the judge for aid paid pending when the county refused to do that. But if you're having issues with aid paid pending, you can always contact State Fair Hearings and they can help you figure out your next step with regard to aid paid pending sooner than going to a hearing. Claimants are the people who have filed for the hearing and they're about authorized representatives. So if you want someone to represent you at the hearing, doesn't have to be an attorney. There's a form that needs to be filled out. Continuances, county responsibilities at the hearings. How do you disqualify a judge? What if there's someone in the hearing who's being disruptive? What can the judge do? Excluding witnesses and observers, the rules on that. Ex parte discussions, in other words, can I speak to the judge about my case? No, I cannot do that just by myself. If I'm going to have communications with the judge, I have to include the county. The explanatory remarks when a judge starts the hearing, these are the things that the judge is going to say, the forms that could be used at a hearing. Oaths, taking an oath, rehearings, etc. Time waivers, withdrawals, any really good information. So those are procedures that need to be followed. Okay, so mom is ready to prepare for her hearing. And she should not have started preparing for her hearing days before the hearing. She should have started the moment that she filed for her hearing, because it may take a while for her to get her evidence together to present at the hearing. But how do you start preparing for a hearing? Well, first of all, mom has to be very clear about what the issue is at the hearing. She got this notice of action that says they're taking away Emilio's protective supervision. That's the issue. That's what her issue is at the hearing. If she goes to the hearing and she starts to talk about other things, other issues that she has with the county, the judge is going to stop her and say, the only thing I'm here is to decide the issue of protective supervision. The other services that that you want or were not approved, we're not here for that. Because in your appeal, you were very specific about why you were appealing, because they were taking away the protective supervision. In fact, if that's the case, that's the only action that the county was taking in that notice of action. So she has to be clear about it. So she is. And she can get that information from the notice of action. In her conversations with the appeals specialist, she might, confirm that that's the issue, and the appeals worker will too. I always say, talk to the appeals worker. Yes, they're going to want to know more about your arguments and your evidence, but you can learn more about the county's argument. I spoke to an appeals specialist who told me what document they were using to take away the protective supervision. And she read it was the IPP from the regional center. And she showed me the sections that they were relying on. I mean, what better deal than that? I mean, I would eventually get to that, but it was nice that I got that information without having to look for it. You have the right to review your file, and that's Manual of Policy and Procedures. And so if you go to this section, 22051.1, that's what it says. 2 days before the hearing, mom has the right to, or Emilio has the right to get the county's position statement. It's gonna have a document that talks about what they did, why they did it, the law they're relying on. And then attached to that position statement is all the evidence and witness that they're going to present at the hearing and the list of witnesses. That's what the county has to do 2 days before the hearing. Now, if mom is signed up for ACMS, she can get all that information by logging on into her account. Otherwise, if she's not signed up for ACMS, she's going to have to talk to the appeals specialist as to how she's going to get that information. Is she going to go to the appeals specialist's office and pick up that information? Can the appeals specialist email it to her? I mean, how is it that she's going to get that information? The county's position statement, electronic transmission, first class mail, pick up at the office. More information on the county's position statement is here in this all county letter, lots of good information. So that when you receive the county's position statement, you know that you're getting everything that should be in there. Okay, so mom has to be clear about the issue. So the issue is that they're taking away the protective supervision because they say that Emilio is self-directing and Emilio doesn't need supervision 24 hours a day, 7 days a week. She didn't, when mom read that, she didn't quite understand what that all meant. But she now, because the second step in preparing for the hearing is understanding the law with regard to her issue. Protective supervision has criteria that needs to be met in order to get it. Up until the time that she started reading about protective supervision, mom thought the only thing she had to say is, my son, you know, he needs to be supervised because he elopes, he does this, he does that. It's more than that. And so where does she find out about the law? She can go to the Manual of Policy and Procedures, the regulations about the IHSS program, and it's going to talk about protective supervision. So if we go to the MPPs for the IHSS program, they look similar in format to the MPPs on procedure. Let's see. Okay. So we've gotten to that link, and the regulations on IHSS start at 30-700. And so you see there's program definitions, the application process, responsibilities. These are all the regulations on the IHSS program, and they go on, you know, further. But let's say that I'm looking for protective supervision. So I do a search function, Control F, and I put protective supervision in my Control F function, and I don't see anything there. So let's go to the next section, which is here, and see if we can't find. It's very odd because I know protective supervision it's not doing it for me. I know that it's in this section here, probably under services. Anyway, believe me when I say program service categories, it's probably in this section 30-757. You're going to find information on protective supervision and what the criteria is and what it isn't. It isn't to anticipate medical emergencies, like let's say someone has epilepsy and you're asking for protective supervision to anticipate that seizure. Not going to happen. And so the other place mom found to understand protective supervision is All County Letter 15-25. So we're going to go to that, and we're going to go there. All County Letter 15-25 clarifies the protective supervision service. So there's a lot of the MPP, like I said, it was probably in 30-757.12 through 0.172. This is directly from the regulations where I was trying to find it. And so there's information on the requirements for protective supervision. And so mom read all of this and she now understood why the notice of action had that Emilio was no longer needed the protective supervision because he was self-directing and didn't need to be supervised 24/7. And we're going to go through the criteria in a moment. But we also have publications online through our GRC website on IHSS program generally and protective supervision specifically. So after mom read about protective supervision, she understood that there was criteria. And for adults or minors, doesn't matter, you have to show that the person has a mental disability that causes them to be non-self-directing. Let me explain that. Mental disability means developmental, psychiatric, traumatic brain injury, dementia, Alzheimer's, some kind of mental disability, mental impairment that causes them to be non-self-directing. Non-self-directing, what does that mean? It means that because of their mental disability, excuse me, they don't understand that the behavior they are doing or about to do is going to cause them injury. It's not to protect others from aggressive behaviors. That's not going to get you protective supervision. It's to protect the person from him or herself. The person has to have the potential to get into danger. If the person can't move a finger or an eyelid, can't move any part of their body, not likely to engage in potentially dangerous activities. But we have had cases where the person is in bed and can get into danger, can have self-injurious behaviors even when they're in bed. The third criterion is that the person needs to be supervised, have the need to be supervised 24 hours a day, 7 days a week. Now, the program won't pay you to supervise someone 24 hours a day, 7 days a week, because that would be something like over 740 hours. But that's the requirement. Now, the first three criteria are for adults and kids, same. The fourth one is only for minors below the age of 18. And so you have to show that the minor needs more supervision than a minor of the same age who is not disabled. And that to me is the easiest thing to do when you talk about the behaviors. You know, when you hear about a 14-year-old wanting to elope and could get into danger if he does, but because he doesn't know how to return home, versus a 14-year-old who knows how to get home, who leaves the house and comes back, those kinds of things. So talking about behaviors for protective supervision is really important. So out of the 4 criteria required for Emilio to get protective supervision, the county is saying that he doesn't meet 2 of them: the non-self-directing and the need for 24/7 supervision. So now mom understands the notice of action better. Now, what does mom need to do? So she has identified the issue. She now knows what the law is with regard to the issue. There's criteria that needs to be met. Now she has to identify and gather evidence that will show that Emilio continues to be non-self-directing, that Emilio continues to need 24/7 supervision. Well, where does she go for that? Maybe the IEP through the school, the triennial, maybe the IPP through the regional center. One important tip: don't just submit documents without reading them and, to hope that something, catches. You've got to make sure that the documents you submit to the county are accurate and that the facts in all of the document are consistent. Because if in one document it says something about an issue, and in another document it says totally the opposite, who is the county to believe? And you've signed both documents. Who's the judge to believe? So the information in the IEP and the IPP, any document you submit to the county has to be consistent and accurate. So let me tell you, I had a client whose mother had applied for protective supervision for her minor son. He was denied. I spoke with her over the phone. I asked her if she had submitted any documents, and she said yes. The county asked for the IEP and the IPP. I said, send them over. I read the IEP, and in the IEP, it said, her mom, son only needs to be supervised while at school. She signed the IEP. It was in English. She's monolingual Spanish speaking. I called her up and I said, I'm reading this in the IEP and it says this. And she said, I never said that. And I said, well, why did you sign the IEP? And she said, well, because I felt pressure to sign it there and then. And plus, they told me that they were going to give me the IEP in Spanish down the line. And I trusted that what I signed was correct, was correct, factually correct. But it wasn't. And I said, well, if you go to hearing on this, this is the way you described it to me is the way you're going to have to describe it to the judge, right? Because I know this stuff happened. Judges know this stuff happens. Because, you know, if to get protective supervision, you have to have a need for 24/7 supervision. And you've got a document signed by the mom saying that he only needs supervision while at school. Well, you know, that's not good. Okay, moving on. Emilio's mom might want to reach out to his doctor or specialist to get a letter that addresses his non-self-directedness, that addresses his need for 24/7 supervision. Records may be helpful too. The SOC 821 is that form that a doctor has to fill out that indicates the functional limitations of the person with regard to memory, orientation, and judgment. Mom had that filled out by the doctor, and the doctor, you know, in some areas it was severe, and in another area it was moderate. But that document in and of itself will not get you protective supervision. This document, along with all the other evidence that the county gathers, will determine whether the person meets the criteria for protective supervision. So just because you submit an SOC 821 with severe in every category doesn't mean that you automatically get protective supervision, because remember, there's criteria that needs to be met. Other things that mom may want to do is talk to the ABA provider. Maybe she could get a letter or the records of the visits where it talks about behavior and what happened and what needed to happen to stop Emilio from continuing the behavior. Was he injured? Was he not? You don't have to be injured to get protective supervision. The program doesn't require that. Witnesses, perhaps a neighbor heard the police outside on the street at 2 a.m. and neighbor came out and talked to the parents, and they said that Emilio had run away. He had left the house. They don't know where he is. And then hours later, Emilio, the police brought Emilio home. He was disoriented. They found him, blocks away. So that kind of witness would be good for the proposition that he is non-self-directing. And secondly, that he needs 24/7 supervision because this happened at 2 a.m. in the morning. Witnesses, you can have your witness testify by phone. So if your witness is going to testify by phone, you need to let the judge know in the beginning of the hearing that that's what's going to happen. And when the judge is ready to take the testimony of your witness, The judge will call your witness, make sure your witness answers the phone. You don't want the judge to call and no answer. You might want to ask that if that happens, you might want to ask the judge to continue the hearing so that you can bring the witness to the hearing or try to get the witness back on the phone. In person, if you're going to have an in-person hearing, the witness can come to the hearing location and testify there. Or you can have your witness submit a declaration. It's a document signed under penalty of perjury and dated. It's the testimony of the person in paper form. That's what a declaration is. Sometimes what's important also is what happened at the home evaluation. Let's say that at the home evaluation, Emilio's mom talked about new behaviors that Emilio has, especially at night. But when mom reviewed the records, Emilio's record file from the county, and she reviewed the reassessment form, none of that information was there. And in fact, some information in the reassessment form was plain wrong. So, she might want to think about cross-examining that social worker about why that information wasn't there, about the behaviors, and why this other information is there when that's not what she said. The facts are wrong. A practice tip is to have someone present when you're being reassessed so that they can write down how long this reassessment took, what did the social worker ask, what did the other person answer, how much time was spent doing an evaluation of need versus having a person sign forms. A hazard log. If mom doesn't maintain a hazard log, it might be a good time for her to do that. So every day she writes down the behavior, what happened, what time did it happen, what intervention was necessary, how long did it take for them to calm Emilio down. Did he injure himself? Did he not? Doesn't matter if you injure yourself or not, but if he did injure himself, is not a good thing. The regional center also has something that's called the CEDAR, and it talks about the person's memory, judgment, confusion. Mom may want to get the CEDAR from the service coordinator to see if there's any useful information there. If mom has any videos of behaviors, photos of injuries, that could be good. Incident report when the police came out, when the parents reported Emilio missing, that may be a very good piece of evidence to introduce at the time of the hearing. There could be other things too. If you're thinking videos, you really need to protect the person from self-injury, right? So I wouldn't expect that you would allow the behavior to happen so that you can videotape it. But if someone else is in the room who could videotape it while you're trying to address the behavior, that would be great. Okay, so identifying the issue, understanding the law about the issue, what evidence, gathering evidence to support your arguments at the hearing. And now mom has to think about whether she wants to prepare her own position statement to give to the judge. She doesn't have to, but she can if she wants to. She could write down, I got this notice of action from the county saying they want to take away Emilio's protective supervision because of these reasons. I disagree. And, Emilio is non-self-directing, and this is why. And here's the evidence I want to present. Emilio does need 24/7 supervision, and here's the evidence, and this is why, and this is what I'm going to present. And by the way, the county has the burden of showing what changed between the last time they approved protective supervision and now that they want to take protective supervision. I've reviewed the evidence from the county, and I don't see any changes to his self-directedness or to his need for 24/7 supervision that would warrant what they're doing. Because the county has to have evidence for saying that he's now self-directed, that he now doesn't need 24/7 supervision. What is that evidence? Do they have that evidence? I went to a hearing once where the supervisor was at the hearing, not the social worker who went to do the assessment. And it was a protective supervision case. And the judge, right in the beginning, said to the county, okay, you have the burden of showing what changed between the last time you approved protective supervision and now. And the the supervisor said something like, well, we were relying on the IPP, and but there wasn't there the IPP had never been submitted, and the judge continued the hearing to give the supervisor the opportunity to look at the prior IPPs to show, and the current IPP to show what had changed, because they said that they were relying on the IPP. I objected to that. I said to the judge, Your Honor, they had all this opportunity. This is not the first time this person comes to hearing. And she knows that the county knows that what their burden is. And you're giving them a second bite at the apple here. The judge didn't pay attention to what I had to say and allowed the county to review their records. And so the hearing was postponed. The county had to, the social worker had to let me and the judge know what had changed. And so before the deadline for the county to do this, we got a letter from the county saying that the only IPPs that they could locate were for some years before. And so they really couldn't establish their burden to show what had changed between the current IPP and the last IPP. And so that was the end of the case. Didn't even have to go to hearing. I mean, technically, we didn't have to proceed to a full hearing because the county couldn't even meet their burden to begin with. But let's going back to Mom's position statement. It's always good because to have a position statement that you give the judge, because the judge is not going to decide the case on that day. At some point in time, the judge is going to decide that case, and it would be good for the judge to have something in writing to remember what it is you said. Of course, there's a hearing, and the judge could listen to the tape of the hearing again if he or she needed to. Always, make a checklist of all the things you want to say to the judge. It's good to have a checklist because you don't want to leave the hearing and then remember, oh, I should have said this or that, and it's too late. So good to do that. The other thing that Mom needs to think about too is preparing questions for her witnesses if she's not going to submit declarations, to cross-examine the social worker who did the reassessment. Why did you put this information in the reassessment form when I never said that? Why did you not include, the behaviors that I told you about? What do you know about autism and auditory processing disorder? What's your educational background that allows you to say that he's self-directing given his autism and his auditory processing disorder? And by the way, do you know where he is on the spectrum? I mean, what you're trying to do is trying to make it so that the judge gets the idea that the social worker really is not qualified to make those kinds of decisions about self-directedness or the need for 24/7 supervision. There may be other people who appear at the hearing, like a psychologist or some medical person that can appear at these hearings at witnesses, and you just have to be kind of ready to sometimes, ask questions on the cuff. Perhaps sometimes judges will ask questions for you because they want to know, right? And especially if you don't have anyone representing you at the hearing, they're going to know that you might not know how to elicit the answers or cross-examine someone who is a medical person. So, hopefully you have a judge who could do that. Conditional withdrawal. So what can happen before the hearing is that mom has been talking to the appeals specialist. A couple of things can happen, for example. One could be the appeals specialist could say to mom, hey, you know what? The county's wrong about taking away the protective supervision. We're going to reinstate it. Let's enter into this conditional withdrawal as a document that says that the county agrees to reinstate Emilio. And of course, mom is going to say, yeah, let's enter into that conditional withdrawal. The other thing that the county could do is that it could say, can we reassess Emilio for protective supervision? And mom can say, no, you had your chance when you came and reassessed him. Again, like I said, this is like a second bite at the apple. And she may just say, no, I don't want to do that. I want to go to hearing. Or she may say, yes, okay, go ahead, hoping that with this reassessment, the county will change its mind. And this conditional withdrawal, whatever the county agrees to do has to be done within 30 days of signing it. And mom has to understand what she's agreeing to. But it's possible that after that reassessment again for protective supervision that she agreed to, that she's going to get another notice saying we're going to take away the protective supervision. So what I want to say is just because the county says we want to reassess doesn't necessarily mean that you're going to get the answer that you want. When you're talking about conditional withdrawals, make sure that there's a retroactive date to the date of the action. So what that means is, so let's say, for example, they've taken away the protective supervision since July 1st, and there's no aid paid pending, and they want to enter into this conditional withdrawal. Just make sure that the conditional withdrawal includes the fact that any retroactive payment will be effective July, did I say June 1st or June 1st, the date that he lost his protective supervision. Otherwise, you might not get retroactive payment. So what happens at the hearing? It's nothing like this. This is in a courthouse. There's no judge with a robe and there's no jury. You're in a room, usually small, and there's a table. The judge is at the head of the table. Each side takes a side. So I may be on the left side with my people. County will be on the other side with their witnesses. So who's going to be at the hearing? The judge, the appeal specialist, social workers, maybe supervisors, maybe someone else from the county. You, the claimant, the person who asked for the hearing, maybe your authorized rep, witnesses, interpreters. Usually those are the usual crowds of people. At the hearing, you're establishing what is called the record. The record is the evidence that was presented at the hearing. There are two forms of evidence: the testimony at the hearing and the documents that are entered into evidence. The documents the judge agrees will be used at the hearing. And so sometimes when you're in the hearing and you realize that you didn't bring a document that you think is very important for the hearing, you could say to the judge, Your Honor, can I leave the record open so that I can submit this document? Because at the end of the hearing, the judge closes the record and no additional evidence can be presented. But if the judge leaves the record open so that you can submit something or the county can submit something, then that can happen. And the judge, if the judge leaves the record open, the judge will tell you how much time you have to submit that evidence, or the county to submit that evidence, and how much time the other party has to rebut that evidence. So it's important to know that you can ask the judge that, because if you don't, the record closes and no more evidence can be presented after the hearing. And the record is used. If you appeal your case, the next level of appeal is to Superior Court for a writ of administrative mandamus. And the judge in Superior Court is going to review the record and determine, and the determination as to whether you win or lose at the Superior Court level is based on the record, all of the testimony that was provided at the time of the hearing. And there are standards for winning an administrative writ of administrative mandamus, but I'm not going to go into that. But in any way, very important. The general sequence of events at a hearing, the judge will provide some instruction in the beginning and then swear the witnesses. We'll review the evidence that the parties have submitted to see if any of the parties object to some of the evidence. If there's objection to some of the evidence, the judge will have a discussion and then decide what evidence comes in. In other words, the evidence that will be used to form the decision. And then the judge will go to the county and say, explain your position. The county will explain its position, and the judge is going to want to hear from the county as to what happened between the last time you approved protective supervision and now. And the county will say, well, we have this evidence that shows that Emilio is self-directing, or that he no longer requires 24/7 supervision. And the appeals specialist could question the social worker or anyone else who's there on behalf of the county. And then Emilio's mom will be able to cross-examine those witnesses. And then when the county's done with their witnesses, the judge will go to mom and say, what's your position? Why do you disagree? Et cetera, et cetera. And mom will talk about it and call her witnesses. And then the appeal specialist can cross-examine her witnesses. Now, I've been at hearings where the judges are very hands-off. They allow people to ask the questions, and that's about it. Maybe, ask a question here or there. And I've been in hearings where the judges are very proactive. They know the information that they want. They're asking the questions. That's great. And so, as I sit here today, I can't tell you what kind of judge you're going to get, but, you need to be ready for those judges that really are, they're not, don't involve themselves too much. And you need to be ready to do what you need to do. But there are some judges that are very proactive, and they get to the nitty gritty. They know what they need. They've read all the information, and that could be very helpful. MPP, remember the Manual of Policy and Procedures on Procedure, 22-073.3 talks about the county's responsibilities at the hearing, to summarize the written position statement, to examine county witnesses, to cross-examine the claimant's witnesses, to respond to any questions from the claimant or the judge, to have the record available, case record, the file. The burden of going forward in the hearing is to support its determination. This one's big. They have a burden to do, and they have to meet that burden. And to have the authority at the hearing to make binding agreements and stipulations on behalf of the county. After all of the witnesses have testified at the hearing, the judge will close the record unless it's been left open, and will give instructions as to the next steps, the timeline for the decision. And then the decision is what the judge decided. However, the director of the California Department of Social Services can change the administrative law judge's decision, and that's called an alternated decision. So it's possible that Emilio's mom will get the decision that says from the judge, where the judge agreed that Emilio continues to meet the criteria for protective supervision. But then on top, and it says void, and then on top of that is the alternated decision. And that alternated decision says that the county was right in taking away the protective supervision. Now, the director just can't willy-nilly decide to do that. The director has to have had to explain why legally and factually the judge was wrong in his or her decision. And so if that's the case, if Emilio receives an alternated decision that says that he doesn't need protective supervision anymore, he has the right to appeal and to Superior Court within 1 year of the decision. And that's an administrative writ of mandamus. At this level, you're looking for an attorney. I mean, people go to court in pro per, meaning they represent themselves, but this is not, if you could find an attorney, that would be better, right? And if you win your case in Superior Court, you can actually ask the court to pay your attorney fees. The other thing that can happen is the decision will have information about asking for a rehearing, and I'll talk about rehearings in a moment. Why do you want a rehearing? You want another hearing on the same issue. Why do you want a rehearing? It's not an appeal. It doesn't have to be granted. Your appeal, your next level of appeal is to Superior Court. It's not a rehearing, but you could ask for a rehearing, and whether they grant it to you or not is up to them. You can also, if you're going to be appealing to Superior Court, you want to get the complete record. In other words, all of the documents that were admitted and the recording of the hearing, because it has all the testimony. Because when you're looking for an attorney, the attorney is going to want to review the record to see if he or she has a good case, right? Can't do that unless you look at the record. Rehearing, remember the regulations on procedures 22-065, request a rehearing. Why you need a rehearing? Gosh, the judge didn't allow my 2 witnesses to testify, and they would have testified as to Emilio's need for 24/7 supervision and his non-self-directedness. That could be a good reason to have a rehearing. You need to state when you received the decision, because they're very particular about the 30 days for filing a rehearing. If you're going to introduce any new evidence, you have to describe and submit the new evidence, state why it wasn't submitted earlier and why this new evidence is material. How is it important to this case, and how this new evidence is going to change the decision. So that's a rehearing. And lastly, complying with the decision. That's the regulations on compliance. So it says that immediately upon receipt of the decision, the county has to initiate action. In 30 days, it has to submit a compliance report to State Fair Hearings. You can contact CDSS or State Fair Hearings, actually, I would contact orally or in writing, saying that either the county hasn't complied with the decision or has not fully complied with the decision. And upon your notifying State Fair Hearings, I would recommend State Fair Hearings rather than CDSS, the county has to take appropriate action to ensure compliance. So that's the MPP on how to get the county to comply. So we've come to the end of the presentation. This is our intake line, and this is our website. For more information on IHSS, we would go to the resource section of our website and go, actually, why don't we do that? If you haven't been to our website, this is what it looks like. It's loading. So we would go to resources. There are different ways to get to our publications, different languages that you can have them in. And these are all the publications that we have. We've got in-home supported services. We've got lots of information here. We've got our You're not happy with your social worker. The manual is right here on IHSS. Our medical services, a specific one on protective supervision. So how hours are calculated. Anyway, we've got information there. So we've come to the end, and I'm happy to take any questions.
And I'm going to go ahead and stop the recording.